Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about a surviving spouse's rights in Iowa probate and answer the question, what is a spouse's elective share in Iowa probate? When someone's spouse dies without a will, the spouse is generally entitled to inherit everything. State intestacy laws declare that a surviving spouse generally gets everything. An exception is when there are children from a previous relationship, in which case the estate is divided in half between the surviving spouse and the children from the previous relationship. That's pretty simple. If a spouse dies with a will, then the surviving spouse has the option to either accept what he or she is left under the will or to forego taking anything under the will and instead file an affidavit stating that they will be taking an elective share of the estate. So this means that regardless of what the spouse is left under the will, he or she is entitled to a certain percentage of the estate. And it basically comes down to 1/3 of the estate. There's a little nuance here. So regardless of what is left to the spouse under the will, he or she is entitled to all non-exempt personal property. And non-exempt personal property is assets other than real estate, and this might be this generally tangible personal possessions or cash or bank accounts, anything other than real estate that would not be collectible by creditors. So there's certain amounts of money, there are certain types of assets that creditors can't go after in Iowa. And the surviving spouse is entitled to all of this if they choose to take the elective share. In addition, they're entitled to 1/3 of the value of any real estate, or alternatively, to just remain living in that real estate. Or 1/3, and not or, 1/3 of the value of all non-exempt personal property. So they get all of the personal property that would be exempt from collection by creditors, and then they basically get 1/3 of everything else. So if the will is less favorable than that, then the surviving spouse should file an affidavit saying that they're going to take the elective share and take their 1/3 of all of the assets of the estate. If the surviving spouse does not file that affidavit, then it is presumed that they're going to accept what they are being given under the will, and the will control. So if you have any questions, you can leave the questions in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please feel free to give us a call, 563-503-6910. We offer free consultations in many areas of law. We have several geographic locations for your convenience. Again, that number is 563-503-6910. We'd also love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.